The Dershow.
Both sides, Republicans and Democrats, are misusing the criminal justice system and weaponizing it. Some of you will remember that when after President Trump was elected, when he was president-elect, but before he was sworn in, I was invited to Mar-a-Lago to give a talk on weaponization of the legal system, on lawfare. And the president, I'd met with him before that, and I told him I was speaking, and he said, "Oh, yeah, I want to come and hear you." And so he came, and he stood up in the back of the room, and I made my talk on lawfare. And I said at the end, the Democrats started it all, obviously, by going after Trump. Letitia James, Attorney General of New York, and the District Attorney of New York both campaigned on the issue of get Trump. And, now they're going after Jack Smith, saying he politicized the legal system. My God, these guys politicized the legal system more than anybody. So it all started, obviously, with District Attorney Bragg and Attorney General Letitia James. Bragg convicted Trump, got a jury with a judge who was one-sided, got a jury to convict Trump of a non-crime. It's just not there. It's not on the books. You can't find it. Nobody can figure out what it is. He listed payments to settle a case as a legal expense. Of course, what I would have done, and I'm a lawyer with 65 years of experience, I would have listed it as a legal expense, but they said, no, that was a misdemeanor. But the misdemeanor was gone by the statute of limitations, so they said, oh, I'll tell you what we'll do. We'll take this misdemeanor, which isn't a misdemeanor because he didn't do anything wrong. In fact, he didn't do anything. It was like a third secretary in his accounting office who did it. But we're going to take this misdemeanor and voila, we're going to turn it into a felony by saying he committed the misdemeanor in order to commit a felony. Wow, that's pretty complicated. The felony was he was going to cheat on his taxes 2 years hence by taking it as a legal expense. Well, A, it was a legal expense. Second, he didn't list it as legal expense on his taxes, and he didn't take it as a tax deduction. So that's just a myth. Then they said he did it to influence the election because nobody really in the world knew that there were accusations against Donald Trump. Oh my God, nobody knew that. There were so many accusations out there, so many lawsuits, that by paying this hush money, he helped increase his chances of being president. That is such total nonsense. It doesn't pass the giggle test, but that's what the Democrats did. So in my speech, I turned to President Trump. He was in the back, and I said, I'm hoping that the Republicans don't sink to the level that the Democrats sunk to, and I hope they don't try to play tit for tat, get even, just because the Democrats went after them and used lawfare against them. I was hoping the Republicans wouldn't use lawfare against the Democrats. The best response to being victimized by lawfare is to just announce, we're not doing this. We're not going to do this. We're not going to have lawfare. We're going to play it straight. And for the most part, they have. But now we're seeing at least indications that maybe the Justice Department will be subpoenaing people, both on the Epstein case, but more importantly on the weaponization cases, and maybe there'll be a grand jury. My answer is no, you shouldn't have a grand jury. What you should have is congressional hearings. That's what congressional hearings are about. They're supposed to be a check and balance on the executive and also on the judiciary. And so the way to do it is to have hearings, subpoena the witnesses. Yes, you can subpoena Democrats. That's fine. Subpoena them and cross-examine them and find out and get their documents. And only then, if there is a significant, substantial basis for opening a criminal investigation, then you open a criminal investigation. You don't engage in ready, fire, aim. It has to be ready, aim, fire. And the aim has to come from subpoenas and testimony in front of Congress, not criminal, civil. And yeah, sure, they can plead the fifth, but they won't. You're not going to get leading figures pleading the fifth. I've been advising criminal defendants for more than 60 years. In all those years, I have never once advised the client to take the Fifth Amendment. I've advised them to take the Fourth. I've advised them to take the First. I've advised them to take the Sixth. I've advised them to take the Seventh, the Eighth, but never the Fifth, never the Second. I don't remember. No, maybe I have the Second, because that, your right to bear arms, if you're being charged with something that violates that right. I certainly have never advised them to take the Third Amendment. Nobody knows what the Third Amendment is. It's people are not allowed to quarter troops in their house except during wartime. But I've never advised them to take the Fifth, because even though taking the Fifth is not an indicia of guilt, it's perceived that way. And, I grew up during the McCarthy period when people were called Fifth Amendment communists. You're a Fifth Amendment communist. So I don't want my client to be considered Fifth Amendment criminals, Fifth Amendment, whatever. So I advise them not to take the Fifth. And I don't think any of these people are going to take the Fifth. They may claim executive privilege. That would be interesting, because many of them opposed the Supreme Court's decision on executive privilege. But hypocrisy is our national byword. So people will perhaps invoke executive privilege, even though they oppose the Supreme Court decision granting a broad executive privilege, a little bit too broad in my own view. But it's hard to deny the executive a privilege when the Supreme Court has already given the judiciary a privilege. Neither is in the Constitution explicitly, and both are probably required to some degree to allow the government to function. But we'll see what happens. We'll see what happens. But I don't like the grand jury being convened first. I think that's always a last resort. And also, by the way, the statute of limitations is probably run on most of these acts. They took place for the most part, 8 and 10 years ago. There may be some that are within the statute of limitations. But again, don't weaponize. Don't engage in lawfare. I don't care if you're a Democrat or Republican. The nation is best served when the criminal justice system is reserved for real criminals who've done real criminal acts, and not for people who are targeted because of their political views. We do not ever want to turn into the country that Lavrenti Beria, the head of the KGB, and Stalin made Russia, when Beria said to Stalin, "Show me the man and I'll find you the crime." In the New York case against Trump, James and Bragg both said, "Show me the man," and the man was Trump, "and I'll find you the crime." And they both searched so hard to try to find the crime. And in neither case could they find the crime. So they made one up. They just made it up. It's not a crime. It's just made it up. I can't believe that the appellate courts will sustain that conviction, but in New York they might. We have to wait and see.